the reasonable restriction, this capability to put those rights into under reasonable restriction, rests with the legislature. But to test the nature of the reasonableness or the reasonableness of such restrictions rests with the judiciary. Remember the preamble, so as the directive principles of state policy and the fundamental duties. Neither of them are enforceable. It means if they are not contained or not enforced, you cannot go to the courts for their enforcement. But fundamental rights, that's why they are fundamental in nature. You can directly move the Supreme Court of India also for their enforcement. Friends, today we will learn about fundamental rights. In fact, some basic civil rights are indispensable for civilized existence in any society. And most of the constitutions all around the world offer these rights. But not all such rights can be categorized as fundamental rights. Say, for instance, there exists some basic civil rights in England as well. And if the executive surpasses those rights, the English courts will declare the actions of the executive unconstitutional. But if the English Parliament makes a law which takes away or abridges any of those rights, the English courts are helpless before the English legislature. Why? Because in England, there exists parliamentary supremacy. In USA, however, the situation is altogether different. Since there exists constitutional supremacy, the rights that are promised by the Constitution are equally binding on the executive as well as the legislature. In other words, that neither executive action nor legislative action can transgress those rights which are promised to the people by the Constitution of the United States of America. Therefore, the civil rights that exist in United States of America can be categorized as fundamental rights. The situation is almost similar in India. Why? Because the chapter on fundamental rights, which is part 3 of the Indian Constitution, we are already done with the part 1 and part 2 of the Constitution. Today we will look at part 3 of the Indian Constitution. So part 3 of the Indian Constitution is modeled on the American Bill of Rights chapter. It means that in India also, these rights are equally binding on the executive as well as the legislature. And therefore, that is the difference between rights of fundamental nature and rights which are just basic civil rights. So, in very simple terms, in England, the rights are binding only upon the executive, but they create no limitation on the legislature, because in England, there exists parliamentary supremacy. But in India, as well as in the United States of America, the rights that are promised by the Constitution, the basic civil rights, they create fetters both on executive fiat as well as on legislative actions. So we will see those rights today in this class, and these are the fundamental rights. Article 12 to 35 contain all the things that are there with respect to fundamental rights. You know that in our Constitution, originally in the Constitution of 1949, there were 7 set of fundamental rights. But one among them, which is right to property, is no longer a fundamental right, because Article 31, which promised to us the right to property as a fundamental right, has been repealed by the 44th Constitutional Amendment Act 1978, and all the matter that was contained in Article 31 is now there in 300A, which is a legal right, and therefore a fundamental right, which was right to property, is now transposed into a legal right and is contained in Article 300A, which falls outside Part 3 of the Indian Constitution. So let's have a look at the 6 sets of fundamental rights that exist today. Originally there were 7 sets. The first one is right to equality, and it is contained in Article 14 to 18, right to freedom between Article 19 to 22, right against exploitation, Article 23 and 24, right to freedom of religion contained between Article 25 to 28, cultural and educational rights, they are contained in Article 29 and 30, right to property, which originally was a fundamental right, but no longer it's a fundamental right, that's why I'm showing it in red ink, and then right to constitutional remedies, which is contained in Article 32, the right to move Supreme Court directly for the enforcement of any of the fundamental rights in itself is a fundamental right, and that is the right to constitutional remedies. Let's have a look at the characteristics of fundamental rights. The first characteristic of fundamental rights is some of them are available only to citizens, while others are available to all persons, whether citizens, foreigners, or legal persons like corporations or companies. Think of Article 15, which says that the state shall not discriminate against any citizen only on grounds of religion, race, caste, sex, place of birth, or any of them. So this right, which is the right not to be discriminated in an arbitrary fashion by the state, is available only to the citizen. Similarly, think of Article 19, which confers some basic freedoms on the individual. They are also limited only to the citizens. Whereas think of Article 14, which says right to equality. It is available to everyone, citizens as well as non-citizens. Second characteristic, they are not absolute but qualified. It means some of the fundamental rights that are contained in Part 3, they are not absolute in nature. They have or they can be put under some reasonable restriction. Now, the reasonable restriction, this capability to put those rights under reasonable restriction rests with the legislature. But to test the nature of the reasonableness or the reasonableness of such restrictions rests with the judiciary. And that is what is contained in the doctrine of judicial review. Now, look here. So we're saying that not all rights are absolute, but some of them are qualified. It means that the state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. It means the legislature can put those rights that are promised under Part 3, some of them, under reasonable restriction. But whether the restrictions are reasonable or not, that would be decided by the judiciary. A good example would be the freedom of speech and expression. It is not an absolute unbridled right. In fact, it can be put under reasonable restrictions, say for example, in the interest of security or sovereignty of India. The third characteristic is all of them are available against the arbitrary action of the state. However, some of them are also available against the action of private individuals. Like say for example, think of Article 15 Clause 2, which says that nobody should be discriminated and everybody should be allowed to access public places, wells, etc. Or think of the abolition of untouchability. Now, these can also be enforced against individuals and not only state. Some of them are negative in character, that is, they place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. Like, think of this, that Article 21 says that the state shall not deny to any person life and liberty. So you can understand it's a kind of negative connotation. Similarly, Article 19 says everyone shall have the right. So it's a positive. Also, if you break Article 14, you find a negative connotation of it and a positive connotation. Like say, for example, when it says equality before the law, it says absence of a privileged class. And when it says equal protection of the law, it means that those who are equally circumstanced will be treated equally. So it's a kind of promise, a positive thing that is being made. They are justiciable, allowing persons to move the court for their enforcement if and when they are violated. Remember the preamble, so as the directive principles of state policy and the fundamental duties. Neither of them are enforceable. It means if they are not contained or not enforced, you cannot go to the courts for their enforcement. But fundamental rights, that's why they are fundamental in nature. You can directly move the Supreme Court of India also for their enforcement. Next characteristic is they are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court. That is the right to constitutional remedy, which is contained in Article 32, which itself is a fundamental right. And remember that Article 32 is also a part of the basic structure of the Indian Constitution. They are not sacrosanct or permanent. It means they can be amended, but while amending the fundamental rights, the Parliament must take this into cognizance that they do not destroy the basic structure of the Indian Constitution. In fact, that is what the situation is as established post the Keshavananda Bharati judgment. So, the fundamental rights, can they be amended? Yes, the answer is yes, they can be amended. But such amendment shall not tinker with the basic structure of the Indian Constitution. Next, they can be suspended during the operation of national emergency, but except the rights that are guaranteed under Article 20 and 21. It means arbitrary arrest and detention, ex post facto legislation, double jeopardy, self-incrimination, all of that, they cannot be suspended even during an emergency. Similarly, Article 19 gets automatically suspended during national emergency if it is proclaimed on the grounds of war or external aggression. However, if it is proclaimed on the ground of armed rebellion, which is internal emergency as sometimes referred from external emergency, Article 19 is not automatically suspended. So keep this also in mind. The scope of operation is limited by Article 31A, 31B and 31C. Now 31A says saving of laws providing for acquisition of states, etc. Mostly laws related to land reforms and all those kind of things. 31B says that those laws which are put under 9th schedule, now they cannot be questioned in a court of law on the grounds that they destroy the fundamental rights contained in Article 14 or 19. But keep this in mind that they can be questioned before a court of law on the grounds that they are breaking the basic structure, because judicial review itself is a part of the basic structure and that cannot be totally removed. Now, Article 31C says that saving of laws giving effect to certain directive principles. In fact, the directive principles that are contained in Article 39 Clause B and 39 Clause C, if the law is trying to enforce those directives, such a law shall not be declared unconstitutional on the ground that it is taking away the rights that are promised under Article 14 or 19. So 31A, 31B, 31C, these are three exceptions to the fundamental right. Their application to the members of armed forces, paramilitary forces, police forces, intelligence agencies and analogous services can be restricted or abrogated by the Parliament. That is Article 33, which says that the set of fundamental rights which is otherwise available to everyone, they can be restricted as far as members of the armed forces, police forces or any department of the government is concerned which is engaged in the maintenance of law and order, security, sovereignty of the country. And that is done mostly for the purposes of maintenance of discipline and the maintenance of the efficiency in their service. Their application can be restricted while martial law is enforced in any area. Martial law means military rule imposed under abnormal circumstances to restore order. That is contained in Article 34. It is different from imposition of national emergency. Now, you see, sometimes when the situation goes out of hand and normal civil laws are inefficient or civil way of administration is inefficient to restore order, often the army is called in. And then the army takes over the general administration. Such taking over of the general administration is known as martial law. Martial law, then the society and the community is managed as per military rules and military regulations. But martial law must be differentiated from military law. Military law is any law which is passed in the Parliament for military or any wing of the armed forces. But martial law is when the army comes into an area and tries to restore order when the situation goes out of hand. So you can see that there are some exceptions that are created with respect to fundamental rights, and we will see them in detail when we go to these articles, don't worry. The next characteristic says most of them are directly enforceable. It means self-executory, while a few of them can be enforced on the basis of a law made for giving effect to them. Such a law can be made only by the Parliament, not by state legislature, so that uniformity throughout the country is maintained. Now, think of this. Think of Article 14, which says that equality before the law and equal protection of the law. No law need to be made to enforce this article. But as far as Article 17 is concerned, which says that untouchability is hereby abolished and its practice in any form is forbidden. To give it effect, the Parliament must make a law. In fact, the Civil Rights Act has been enacted to give this very article effect. So some of the articles are self-executory. It means you do not need an appendage, a law which is made by the state legislature to enforce it. State legislature here means the Parliament. And some of them need that requirement. It means there needs to be some sort of legislation passed by the Union Legislature to enforce the fundamental rights. So some of them are self-executory, whereas some of them needs activation in the form of laws that are passed by the parliaments.